Hello and welcome to Moneylife. This is Sucheta Dalal. This week, we're talking about something different. We're talking about the threats to Justice Gautam Patel, retired judge of the Bombay High Court. To my mind, they picked the wrong judge to intimidate. But the real damage could be to every one of us, the citizens of India, who depend on an independent judiciary. For those of you who don't know, Justice Gautam Patel has made public disclosures after a long time about the threats and attacks on his family, which I believe have crossed a dangerous line for the Indian judiciary. This is an institution that's beset by serious hazards, both external and internal. In June 2026, very recently, Justice Patel has revealed how a global syndicate had systematically intimidated, targeted, and attacked his immediate family in London in an attempt to force him to do something amazing. They wanted him to recant his landmark judgment in the decade long Dawoodi Bohra succession dispute. Now, if you know, this is literally a sect which follows Islam, and the facts in this case are pretty chilling. In April 2024, just before his retirement, Justice Patel ruled that Sayyidina Mufaddal Saifuddin had validly succeeded as the 53rd Dai al Multak of the Dawoodi Bohra community, which is the head of that community. This judgment came after long hearings in the court, was consistently heard by Justice Patel, and immediately after, obviously, one side didn't like it, so the judgment was appealed. What has now emerged is that over the following 10 months, Justice Patel and his family were subjected to an extraordinary campaign of threats and blackmail. It wasn't made public, he did not speak about it, but he made all the right complaints without it being in the public domain. Now, what happened? The operation included repeated attempts to break into his daughter's home in London. She's a British citizen. All through 2025, this followed letters delivered simultaneously in London and in Mumbai demanding that Justice Patel produce a YouTube video in which he recants his verdict, and the script demanded that he would claim that the judgment that he delivered was under duress and coercion, and the successful defendant was the one who had influenced the verdict. Not only that, it wanted him to then verify this judgment by speaking about it to the media and to his associates and the judiciary. He refused to do it. The intimidation then escalated. On 22nd April 2026, almost like a year to his judgment, a masked assailant attacked his daughter near her home in London, did it very carefully, found a blind spot, and hit her repeatedly, fractured her nose, kicked her. Again, at that time, a case was registered, but there was nothing to link that attack on the threats. But this changed on 5th June. Justice Patel was in London with his daughter, and they received a letter which enclosed a body cam footage of her being attacked. This time, the letter explicitly stated that a gang had been fully paid to attack him, and the next step would be the cremation of him and his family, including his daughter, her husband, and their children, unless he complied with the earlier demands, which is to recant his judgment. He believes that the perpetrators deliberately exploited the jurisdictional gap between Mumbai and London to frustrate action by law enforcement agencies on both ends. He, of course, refused to yield, and his family stayed strong and supported him. It requires a lot of courage, and frankly, it is scary when you have this kind of global intimidation and have already faced an attack. But the fact that the dots were joined and he went public seems to have led to a spectacular self goal behind those who were responsible for this intimidation. By sending the body cam footage, they transformed what was a private threat and coercion campaign into a public scandal, because now it was clear who was responsible for it. Obviously, the judge went public, and the disclosures provoked outrage in the legal fraternity. It prompted intervention by the Chief Justice of India, who demanded protection for his daughter in London. It led the Bombay Bar Association to demand police protection and a comprehensive litigation. In fact, they filed a PIL. But to my mind, The attack couldn't have come at a worse time for the Indian judicial system. Remember, people are fed up with massive case pendency, chronic delays, high litigation costs, unexplained recusals by judges in high profile matters, and growing concern over the quality of some of the judgments. All these have eroded public confidence in the higher judiciary. Now, add to that the controversial judicial observations against activists, NGOs, civic activists. It has only deepened public frustration. In fact, the satirical launch of the Cockroach Party of India is a part of it. It was a result of things that the Chief Justice no less said in court. It's against this backdrop that you now have an attempt to intimidate a judge who's widely respected for his independence, constitutional commitment, and willingness to decide difficult cases without fear or favor. And all this assumes such serious significance because it's not about one dispute. Let's look at what that case is and the appeal. So, the succession suit was originally filed by Khuzaima Kutubuddin. He claimed that he, not Sayyidina Mufaddal Saifuddin, had been designated by the 52nd Dai as the Sayyidina, now the head of the Dawoodi Bohra sect. After Kutubuddin's death in 2016, his son Tahir Fakhruddin continued the litigation as plaintiff. Justice Patel's judgment concluded that the plaintiff had failed to prove the alleged nas, which is designating him as the Sayyidina, and that the documentary and oral evidence was overwhelmingly supporting Sayyidina Mufaddal's claim. Now, Tahir Fakhruddin appealed. In December 2024, it went before a division bench of the Bombay High Court, which admitted the appeal, agreed to expedite it, but also directed that pending its disposal, the appellant should not publicly describe himself as the leader of the Bohra sect, which is the 54th Daiul Mutlaq. After that, you have these attacks. Now, both sides to the litigation have strongly condemned the criminal acts and denied any involvement. It's equally possible that overzealous followers in a cult like religion can act independently of their own, and this is a international religion. Yet the episode has already proved counterproductive for those who are behind it and who tried to threaten the judge. One, because of Justice Patel's reputation as being a fiercely independent judge. It has united the legal fraternity in his support because they know that the allegations that he was coerced by one side are completely fake. The attack has also caused concern well beyond the immediate litigants because it strikes at the independence of the judiciary itself. The appeal now faces an uncomfortable situation. The composition of the division bench, which heard it in December 2024 and issued that interim order, changed in Jan 2026. Then one of its members recused himself because he had appeared for one of the parties before being elevated to the bench. 6 months later, a new bench has not yet been assigned. Question is, who will be willing to be part of that bench? Who would be willing to hear this case? Why would any judge expose his or her family to the risk of threats and intimidation or even physical attack by presiding over a dispute that has already produced such shocking consequences and could flow over even into their retirement? Can you really realistically expect any judge to do so while those who are responsible for these threats remain at large? Much will depend on whether the Mumbai police makes meaningful progress in identifying and prosecuting the perpetrators. Another equally troubling concern is that any appellate decision that deviates from Justice Patel's judgment is bound to invite speculation. The speculation would be that it may have been influenced by intimidation, coercion, and inducement. So, public confidence in the outcome, whichever way it goes, is going to be at risk. After all, judges are threatened only when other means of influence have failed, right? I mean, if you can win over a judge by other means, you don't need to threaten. The implications, again, like I said, extend far beyond this litigation. The demand that a retired judge publicly recant his judgment has profound consequences for every judge who's going to be hearing any sensitive case involving powerful religious leaders, organized criminal syndicates, influential politicians, or even large corporate interests, money bags. I mean, it hasn't happened before. We don't know what has happened. We always know that coercion and intimidation has come into the public domain. But if people have quietly caved in the past, does anyone know about it? If pressure groups conclude that judges can be reached through their spouses and children, every high stakes case in India becomes vulnerable to extrajudicial coercion. And mind you, this has spilled out in the public domain. We don't even know what has happened behind really weird judgments, and now we are beginning to ask questions. So, what can the state do? Can the state provide lifelong security to a large number of judges? Remember, the biggest of cases, including terrorism, start at the lower courts. And you have to then provide security to all these judges post retirement. The reality will inevitably force judges to weigh the personal cost because they are on their own. What is the personal cost of delivering a legally correct but unpopular decision? They will ask whether an uncompromising judgment could condemn them to permanent police protection. Nobody likes that. Or expose their families to intimidation well after they've demitted office. I'm repeating this because it's a serious issue. And the moment this fear enters a judge's mind, the rule of law succumbs to external pressure. Ironically, we actually have a Judges Protection Act of 1985, but the Act only shields them from civil and criminal cases for acts done in the discharge of their judicial functions and whatever they say in court. It offers no protection against physical threats or violence, particularly after retirement. In Justice Patel's case, it required the personal intervention of the Chief Justice of India to secure protection for his daughter in the United Kingdom. Now, if India is to maintain the perception of an independent judiciary and to prevent a sharp increase in recusals, remember now we are even questioning all those strange recusals that you see from time to time without explanation. If you don't want that to destroy faith in the judiciary, the state must treat this as a direct assault on one of the three key organs of the Constitution. This not only demands enhanced security, but a thorough investigation that swiftly identifies, prosecutes, and punishes those responsible. This cannot drag on for years. In fact, this has to be settled first before that division bench is able to act and do anything. Now, Justice Patel has made a public statement. In this, he notes that the Dawoodi Bohra community, and this is important, the Dawoodi Bohra community operates one of the most sophisticated community management systems of any religious group in the world. It issues digital identity cards, maintains detailed records of its global membership, and operates extensive intelligence networks that enable its leadership to monitor, manage, and communicate with members across dozens of countries in real time. These are facts that the community itself has publicized with pride. Against this backdrop, Justice Patel has said it's simply not credible for either faction to claim ignorance of who within this network commissioned the violence against his family. Equally, there is little purpose in both sides professing innocence or the plaintiff alleging that the entire episode is merely an attempt to malign him and derail the appeal. In fact, he says, and I'm quoting, if this campaign is allowed to succeed or simply to continue without accountability, it sends a message to every member of the Indian judiciary who may be asked to rule on matters touching this or any other community that doing so carries a price payable not by the judge but by their family. This is an attack not just on my family but on the integrity of the Indian judicial system itself, he wants. This is one of those cases where the state's response will matter more than the crime itself. If the investigation ends in another unsolved file, the message will be that highly sensitive cases, the courtroom will not be the place where verdicts are contested.